we're here today celebrating our annual symposium. This is a collaborative effort between the Native American Studies program and the OU College of Law. We have invited tribal members, tribal leaders, tribal judges from across the state of Oklahoma. We also have a lot of attorneys here today because we're getting a CLE accredited, students, professors, and we're all here today to collaborate and dialogue about some really important issues that are happening in Indian country. It's really the perfect setting for a symposium of this stature. We've become the third largest American Indian symposium in the nation, and that happened in just a couple of years. And whenever I was talking to the Native American Studies director who I worked with to help plan this event, he said, we need to make this the pulse of the drumbeat. And so that's really what we're trying to do and bring all of these people together for this important event.
Indian law is increasingly important as an area that law students really need to know about, especially in the state of Oklahoma, but really anywhere. There are lots of statutes that affect tribes, tribal members that have national application, and folks really need to understand how all this works. Tribal advocates and people interested in doing business with tribal governments, which also increasingly happens. We're very proud of our program at the University of Oklahoma College of Law. It's one of our two core programs. We get lots of institutional support. We have lots of students. About 9 to 10% of our student body at the law school are enrolled tribal members. We have a pretty aggressive placement program. We've got graduates all over the United States working in Indian law. And as I mentioned, there's a lot of support from the administration for the program. We did a rough count a few years back and discovered that slightly over half of all of our law students were graduating having taken at least one course in federal Indian law, which is really, really terrific. So there's certainly an appreciation in the law student body that this is stuff they really need to know. We try and train our students to understand what the rules are. And then a lot of them will go out and try and work with tribes, with their tribes or others, to try and help them make things function internally so that they can take advantage of the structure that they're operating in. There have been Supreme Court cases that we have to pay attention to, 10th Circuit cases. There have always been a disproportionate number of Supreme Court cases on Indian law, but it's probably a smaller percentage now than it was back in the 1980s. When we had a lot of our major modern precedent set. Now, what Indian lawyers are spending a lot of time doing is helping tribes negotiate with each other, with outsiders, and with the state over issues that are of mutual interest to both parties in negotiation.
The theme of the conference is breaking down barriers, and I believe it's a fantastic opportunity to move forward. It's a fantastic opportunity for the Indian nations, as well as representatives from the surrounding states, to be here and learn about sovereignty, federal Indian law. What would it take to work together toward the future where we could maybe establish memorandums of understanding, memorandums of agreement, so that we can live in the solution and work toward the future, because we not only represent the Indian nations, we not only represent Indian and non-Indian, but we represent America as a whole. The National Farmers Union Insurance Company versus the Crow Tribe of Indians. When I look back at it, I was 10 years old at the time. And sovereignty symposiums didn't exist in Montana at that time. Unity did not exist in Montana at that time. And I believe the misunderstanding of tribal sovereignty, the misunderstanding that tribal nations have a relationship with Congress, I believe that if we had symposiums like Breaking Down Barriers, maybe we could prevent conflict and find solutions early, so that we could expedite the process quickly at a lesser expense and the loss to the parties emotionally and mentally as well. I mean, you'd save a lot of, to put it plainly, heartache in the end.